Video 49S, Free Speech and the Constitution. First of two videos I hope to make. I'm not sure if it'll work out like that. It's the 28th of November 2022. You're welcome back. Now, the Irish Constitution is partly modelled on the American Constitution, but one of the provisions that's carried over into both constitutions is the concept of habeas corpus, and that dates back to Magna Carta, which was signed at Sunnymead between the noblemen and the barons and the king. And it was always seen as a basic document for government. But the right, the what do you call it? The habeas corpus means production of the body, and the key to that was that the body of the person detained had to be produced before the High Court. And so, if you get a person, we'll say, for example, this person may be a little bit mentally unsound or something, and the Gardaí or the Customs or somebody decides to lock them up for over the weekend while there's a carnival on or something, and they have a right to have the lawyer go to court and have the judge inquire into their detention, and they can order his release in certain circumstances. But key to it is that the judge can and sometimes must demand that the body of your man is brought in. If it is dead or alive, he has to be shown to be actually in existence. This was probably to get over the fact that your man might be dead or something. You have to actually bring him in, no matter who he is or what condition he is, bring him into the courtroom before the judge. And that is a very important concession by the king at the time. Now, the thing about it is that that's contained in Article 4 of the Constitution of Ireland, known as Bunreacht na hÉireann. No citizen shall be deprived of his personal liberty, save in accordance with law. And this is very important in the Constitution. It's all save in accordance with law. All the rights that are given have an opt-out clause, save in accordance with law. Upon complaint being made on behalf of any person to the High Court, any judge thereof alleging that such person is being unlawfully detained, the High Court and any judge to whom the complaint is made shall forthwith inquire into the said complaint and may order the person in whose custody such person is detained to produce the body of such person before the court. And it goes on and on to say what the judge can do, including order his release. Now, a funny thing is that up to 1984, the guards had no power to arrest a person for questioning for ordinary offences. Under the Offences Against the State Act 1939, there were 5 scheduled offences. Going by memory, it's the Firearms Act, the Explosive Substances Act, the Conspiracy and Protection for Property Act, the Criminal Damage Act, Malicious Damage Act, and there was some other one as well. The Offence Against the State Act itself. And if one of those was suspected, the guard could arrest and could detain the person in custody for a day, and the chief superintendent could order the person be detained for another day, and that has been amended a bit, give longer time. But the point about it was they could legally hold him, they could legally question him, and the evidence obtained while he was in custody could be produced in court against him. But there was nothing for non-scheduled offences, and there used to be cases where there was a murder maybe, and some fella hit another person over the head with a frying pan and broke the frying pan, and the guards would use the damage to the frying pan as evidence that there was criminal damage, and is enough to arrest them under Section 30 of the Offence Against the State Act. But it's incredible that it took until 1984 to bring in Section 4 of the Criminal Justice Act 1984, which allowed the guards to detain and the person for questioning for 6 hours, and with an extension of further 6 hours and all of that. So that's the way it was. And in relation to all the controversy about Mary Boyle, remember there was no power at all for the guards to arrest any person for suspected abduction or even murder of the person, unless there was firearms used, and there wasn't, or other explosives. So that's something that is not made common. Indeed, there was no convictions in Ireland for murder where the body was not found until Captain Robert Nyrick's death and conviction for murder years later. So that's important to understand. Now, so that's the thing. There was no power. The guards, maybe there'd be a robbery in the bank, and the guards would go up to your man's house and take him in and say, here, are you all right to stay here for another while? And they'd be trying to get evidence of him, when in fact they should have charged him immediately or let him out. But that's the right to personal liberty. And we'll go on now to the next piece, which is more important, and that is Article 46. Article 50 is the right to your private property and your private house or dwelling. But then Article 6 states the state guarantees liberty for the exercise of the following rights subject to public order and morality. The right of the citizen to express freely their convictions and opinions. Right? The right of the citizen to express freely their opinions, to their convictions and opinions. Okay? That's sub-article 1. It's actually I, in fact, it's sub-article I, but it's an I for 1. It's Roman numerals. The education of public opinion being, however, and that's the key word, however, the education of public opinion being, however, a matter of such grave import, of such grave importance. So they see that public opinion and propaganda was actually written into the Irish Constitution. Such a grave matter to the common good. What's the common good? Is that the good of the government? See, the common good is subjective. The state shall endeavour to ensure that organs of public opinion, such as radio, press and cinema, while preserving the rightful liberty of expression, including criticism of government policy, shall not be used to undermine public order and morality and the authority of the state. Now, you see, I wouldn't have a problem with the authority of the state provided the laws are properly enacted. The SEA Directive Article 3.2 demands that all the renewable energy programs in Ireland and all the energy programs be assessed under Article 3.2, and they refuse to do it. So what legitimacy has government which does that, which breaks the law deliberately, which is our entitlement? Now, so if you look at it again just on that, the education of public opinion being, however, a matter of grave import to the common good, the state shall endeavour to ensure that organs of public opinion, such as radio, and that would be television as well, press and cinema, while preserving their rightful liberty of expression, including criticism of government policy, shall not be used to undermine public order or morality or the authority of the state. The publication or utterances of seditious. So what's seditious? When I claim that the climate change thing is a hoax and that the COVID lockdowns were a hoax after a couple of months, is that seditious? This is the problem. I'm just trying to inform you. Now, seditious or indecent matter, I'm not too concerned about the indecent matter, is an offence and shall be punishable by law. It's not to say you can't do it. It must be punishable by law. So what is sedition? Right? I know to say that the police force has no authority and shouldn't be in existence, that would be kind of seditious. To say that the Irish Army has no right to exist, or that you should kick them every time you see them, or that would be seditious. I wouldn't be in favour of that at all. That's not what I mean. I mean where there are laws on all this woke, climate change, renewable energy, electric cars, all this baloney. Is that seditious? You see, this is the problem. The right now. The next thing is sub-article 2. The right of citizens to assemble peaceably and without arms. Well, we don't want arms. We can't assemble with just without arms. The number's point. No, but that's all right. We haven't a problem there. You have the right to assemble. Now, provisions may be made by law to prevent or control meetings, which are determined in accordance with law to be calculated to cause a breach of the peace or to be a danger or nuisance to the general public and to prevent the control of meetings in the vicinity of either house of the Oireachtas. Well, you see, up in Northern Ireland, the orange parades can sometimes be very provocative, and they did use that. They had to be licenses for parades and marches and to control them and all of that. So I suppose we can't say that should be imposed up there, but just to read that again, and not down here, provision may be made by law to prevent or control meetings which are determined in accordance with law to be calculated to cause a breach of the peace. Well, what happens if the other side causes it? What happens if the woke crowd attack us? So, you see, again, I'm not making too big an issue with this. I mean, the H-Block riots long ago, they tried to burn down the British Embassy. The law has to come down on the side of the Gardaí in that case. The right of citizens to form associations and unions is there. Laws, however, may be enacted for the regulation and control of the public interest in the exercise of the foregoing rights. So one of the things I don't like there is associations, even a union, but an association. I'm a member of the European Platform Against Wind Farms and several anti-wind farm groups and a Pylon group in County Cavan. And so the right of citizens to form associations or unions. Laws, however, may be enacted for the regulation and control of public interest of the exercise of the foregoing right. So you see, the key there is the public interest. When this constitution was written, the public interest was fairly simple, although it is probably said that the Catholic Church's ability to dictate to everyone was an excess. Now we have the public interest moving in the form of woke, cultural Marxist, climate change, green, LGBTQ, and all of this stuff. And that's now moving to where a teacher cannot call a boy him. And this is how the goalposts are moving. So that's all right. That's what I'm telling you there. So do you see the way it's trimmed down in the public interest? And that's subjective. And the last one here is laws regulating the manner in which the right of forming associations and unions and the right of free assembly may be exercised shall contain no political, religious or class discrimination. Now, I have no problem with unions. There had to be regulations on trade disputes and all of that, and what was right and what wasn't, and things brought in. That was done, and you still can exercise your right to have a union and all that. That would be a sad day if that was gone. And also laws regulating the manner of forming associations. There isn't that much of them actually in Ireland, would you believe? And when you go to court, an informal association does, but it might be yet. But anyway, the right of free assembly shall be exercised with no political, religious, or class discrimination. And this brings into question, you see there, if you look at it, political. I mean, my political objective is to crush the Green Party and its members, to crush them. I went up and I campaigned negatively in Churchtown against Alex White because of his energy policy. And was that strictly legal? No political. What's wrong with political? What's wrong with being against these rascals? I mean, it doesn't mean that it's banned as such, but still, I don't see why I can't have an association. Strictly speaking, Fine Gael is a political association designed to keep out Fianna Fáil. I mean, it's a bit ridiculous, that point. And then religious as well. Well, I mean, if it's the Catholic Boy Scout Society or the Protestant Church of Ireland Cyclist Association, why can't it discriminate? I don't really get the point in that. And class discrimination, well, what the hell? I just sometimes fool people, and I'll say to people on social media that I'm high class or something like that. Drives them absolutely nuts. But yeah, I suppose that, but the golf clubs used to have a certain amount of class thing in them, and there was a certain amount of anti-women thing and all that. And so that section may not mean very much. Anyway, folks, it's 13 minutes. The next thing that the article goes on, Article 41, which is the family, and it says the state recognises the family as the natural primary and fundamental unit group of society, and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law. So the Constitution did say the family. Well, then the family, what's the family then? See, that's under attack as well. And so you see the point there that goes on then to say the state therefore guarantees to protect the family in its constitution and authority as the necessary basis of social order and indispensable to the welfare of the nation and the state. I tend to agree. There's nothing as nice, there's nothing as satisfying for a single person or a married person or any person or a widow or anything else as to see a man and woman who get on well, rearing a few children and knowing that the kids are happy. I mean, that fills the heart with joy. Like, I mean, that's the way it is. But I'm just after giving you now a basis of the Constitution, and when we're talking about free speech, and then we'll go on to look at the free speech aspect of it. And for now, anyway, give me a thumbs up and a thumbs down on 15 minutes roughly. Bye, we'll see you.